My name is Hannah Cole. I'm 36 years old, and I work as an urban planning consultant. My job has nothing to do with money, law, or inheritance. It has everything to do with details people overlook because they're inconvenient. I wasn't in the room the day my name disappeared. My father was still alive then. Not strong, not sharp the way he used to be, but legally competent. He'd been diagnosed with early cognitive decline the year before. Nothing dramatic. Nothing that required guardianship. Just enough confusion that my sister insisted we simplify things while he can still decide for himself. I believed her. I was out of state on a work assignment when my sister Laura took him to his attorney's office. She called afterward, her voice light, almost relieved. "It's done," she said. "We updated the will. Dad wanted things cleaner. I didn't ask questions. That's the truth I have to live with." 2 days later, the certified copy arrived in my mailbox. I sat at my kitchen table that evening, skim-reading the document the way people do when they expect everything to be fine. It took a full page before my brain caught up with my eyes. My name wasn't there. The investment fund, $10 million my father had always said was meant for both of us, listed only one beneficiary, Laura. At first, I assumed I was missing something. A rider, an addendum, a clause buried later in the document. I read it again, slowly, line by line. There was nothing. I stared at the signature page longer than I should have. My father's handwriting was familiar to me. I'd seen it on birthday cards, notes on the fridge, checks he insisted on writing by hand long after everyone else stopped. This signature looked tired. The pressure was uneven, the downstrokes heavier than usual, the loops incomplete. And one thing I couldn't explain at all, the ink on the final page looked darker. Not fresher exactly, just different. I called Laura. She sighed before I even finished my sentence. "Hannah, you're overthinking this," she said. "Dad was clear. He wanted it this way." "Why wasn't I there?" I asked. "You were busy," she replied. "And honestly, you get emotional about these things. That stung more than it should have." I called the lawyer next. He sounded cautious, careful in a way that told me he already felt exposed. "The document was signed properly," he said. "Your father appeared willing and aware." "I'm not questioning that," I said. "I'm asking why one page looks different." Silence. "Finally," he said. "If you have concerns, you're entitled to raise them in probate." So I did. Not because I wanted a fight, because I wanted the truth. The hearing was scheduled 3 weeks later. Laura didn't look at me when we sat in the courtroom. She kept her hands folded neatly, confident the way people are when they believe paperwork ends conversations. It doesn't. When the handwriting expert took the stand, she didn't talk about motives or family dynamics. She talked about pressure, ink saturation, drying time. She explained how one page had been substituted, how the ink on that page was significantly newer than the rest, how my father's signature showed signs of having been written after the document was assembled. The room was silent. Science doesn't raise its voice. Before I tell you what the judge said, and what that meant for Laura, I want to ask you something. Have you ever trusted a document because everyone told you it was final, only to realize later that final doesn't always mean honest? If this resonates, leave a comment. I read everyone. Now let me tell you what happens when ink tells the truth people try to hide. The handwriting expert didn't look at my sister when she spoke. She didn't need to. She addressed the judge directly, her voice steady, almost instructional, as if she were explaining a process rather than dismantling a family. "Handwriting isn't just shape," she said. "It's pressure, rhythm, sequence. It leaves physical evidence." She lifted 2 enlarged exhibits displayed side by side on the screen behind her. One was the final page of the amended will. The other was a signature sample from my father's medical records, dated 6 months earlier. "These are not contemporaneous," she continued. You can see it in the ink. She explained how ink ages, how it oxidizes, how saturation changes over time, how paper absorbs ink differently depending on humidity, pressure, and sequence. The ink on this page, she said, indicating the one that removed my name, is significantly newer than the ink on the rest of the document. By approximately 3 to 5 weeks, a murmur moved through the courtroom. Laura shifted beside her attorney, just slightly, enough for me to notice. The expert wasn't finished. Additionally, she said, the pressure pattern in the signature suggests it was written after the page was placed on a harder surface, likely on top of other pages. She zoomed in on the signature line. You can see the inconsistent downstrokes. The pen hesitates. The pressure increases abruptly in places where the writer appears to be compensating. She paused, then added, this is consistent with someone signing a page that was not originally part of the document set. The judge leaned forward. Are you saying the document was altered? He asked. I'm saying, the expert replied carefully, that this page was substituted after the rest of the document was prepared, and the signature was added later. Laura's attorney stood quickly. Objection, speculation. The judge shook his head. Overruled. The witness is explaining physical findings. I watched my sister's hands then. They were still folded, but her thumbs were pressing into each other, hard enough to blanch. The lawyer who had drafted the amendment was called next. He looked smaller on the stand than he had in his office, less certain. Yes, he admitted. Ms. Laura Cole brought the document to me. I did not personally witness the initial drafting of every page. Did you meet with Mr. Cole alone? The judge asked. No, he said. Ms. Cole was present. And did you compare this amendment to the prior version line by line? The lawyer hesitated. No, he said quietly. I relied on the representation that the changes reflected Mr. Cole's wishes. That reliance hung in the air. When Laura finally spoke, it wasn't a defense. It was an explanation. I was trying to help, she said. Dad was confused. He kept changing his mind. I thought simplifying things would reduce stress. For whom? The judge asked. Laura opened her mouth, closed it. The judge ordered a recess. In the hallway, family members whispered. Some avoided my eyes. Some looked at Laura with something like disbelief. She stood rigidly near the wall, her attorney murmuring urgently at her side. I didn't approach her. I didn't need to. When the hearing resumed, the judge's decision was measured and precise. The amended will is invalid, he said, due to material alteration and improper execution. Laura inhaled sharply. The estate will revert to the prior valid document, he continued, and the matter of potential undue influence is referred for further review. No gavel slam, no raised voice. Just consequences. Outside the courthouse, Laura finally turned to me. I didn't erase you, she said. I just moved things. I looked at her then. Really looked. You assumed I wouldn't notice, I said. There's a difference. She didn't reply. In the weeks that followed, the fallout was quiet but thorough. The investment fund was frozen pending redistribution. Laura's authority evaporated overnight. The lawyer faced a professional review. My father, who had passed 2 months after the signing, was spared seeing any of it. I wasn't angry. I was tired. Tired of being told not to ask questions. Tired of being framed as emotional for wanting clarity. Tired of watching confidence substitute for honesty. What stayed with me most wasn't the ruling. It was the expert's testimony. How ink remembers, how paper keeps time, how the smallest physical details outlast explanations. If you've ever been told to let something go because it's already done, I want you to remember this part. Done doesn't mean right. Final doesn't mean true. Leave a comment and tell me. Have you ever questioned something everyone else wanted to move past? Now let me tell you what I chose to do after the ruling. When the courtroom emptied and the noise finally stopped. After the ruling, Everyone seemed to expect something from me. Anger, relief, gratitude, a speech. I offered none of it. The courthouse emptied the way it always does, slowly at first, then all at once. Laura's attorney left without making eye contact. The lawyer who'd drafted the amendment lingered just long enough to look embarrassed before disappearing into a side hallway. Family members clustered in small, uncertain groups, whispering about misunderstandings and good intentions. I walked outside alone. The air felt different, lighter, but not in a celebratory way, more like the pressure had finally equalized after weeks of holding my breath. The following days were administrative, necessary, unemotional. The court reverted the estate to the prior valid will. The $10 million fund was placed under a temporary administrator, pending proper distribution. My name was restored, not as a favor, not as a concession, but because it had never been meant to be removed in the first place. Laura stopped calling. At first, I thought she was giving me space. Then I realized she was recalculating. People like my sister don't disappear. They reassess. They look for angles that still work, but there weren't any left. The handwriting expert's report had circulated quietly among the attorneys involved. The lawyer who'd trusted Laura's representations was advised to review his intake procedures. The phrase sounded polite, but everyone understood what it meant. I received one message from Laura a week later. I didn't think it would come to this. I stared at it for a long time before replying. It came to this because you thought it wouldn't. That was the last thing I said to her. My father's estate settled 3 months later. No further challenges. No appeals. The process did what processes are supposed to do when they're allowed to function. Slow, methodical, indifferent to emotion. At the final distribution meeting, the administrator explained the numbers in the same flat tone I'd heard so many times before. Percentages, accounts, timelines. Laura sat across from me, quieter than I'd ever seen her. Smaller, somehow. Not defeated, just exposed. When it was over, she stood, nodded once in my direction, and left without a word. I didn't follow. In the weeks that followed, people reached out. Distant relatives, old family friends. Most of them said the same thing. I had no idea. She always seemed so capable. I guess you can't trust anyone these days. I corrected none of it. This wasn't about trust. It was about assumptions. I'd assumed being reasonable would protect me. Laura had assumed confidence would protect her. Only one of us was right. What stayed with me wasn't the money. It was the precision of the testimony, the way pressure marks and ink age cut through every story Laura had told herself. How facts, once established, didn't need defending. They just existed. I went back to my life, back to my work, back to the projects that had nothing to do with inheritance or hearings or signatures. But something fundamental had shifted. I no longer apologized for wanting to verify. I no longer softened questions to spare feelings. I no longer confused peace with silence. Because here's what this experience taught me. People don't erase you with grand gestures. They do it with edits, with substitutions, with the quiet confidence that no one will check. But paper checks, ink checks, time checks. If you've ever been told to accept something because it was already signed, I want you to remember this story. Signatures don't end conversations. Evidence does. Before we end, I want to hear from you. Have you ever had to prove something you were never supposed to notice? Something everyone else wanted to move past? Leave a comment and share your experience. Your story might help someone else decide to look a little closer. Because being erased only works if you stay gone. A year passed before I realized how deeply that hearing had changed me. Not in the ways people expect. I didn't become suspicious of everyone. I didn't start documenting my life like a case file. I didn't lose faith in family, or in the idea that people can act out of love. What I lost was something quieter, The instinct to doubt myself. For most of my life, I'd been the reasonable one, the flexible one, the person who could be talked into waiting, into trusting, into not making a fuss. I'd learned early that being calm and cooperative made things easier for everyone else. That habit nearly erased me. After the estate settled, Laura moved to another city. No announcement, no explanation, just distance. We haven't spoken since the final paperwork was signed. I don't know if she ever told herself a different version of the story, one where she was misunderstood instead of caught. I don't need to know. Our extended family adjusted in subtle ways. Conversations became more careful. Decisions were written down. People asked follow-up questions they never would have asked before. Not because of me, but because something fragile had been exposed. Trust isn't destroyed when the truth comes out. It's destroyed when the truth is hidden and discovered later. As for the money, it did what money always does. It settled into accounts. It funded practical things. It lost its drama the moment it stopped being a weapon. What stayed dramatic, what stayed with me, was the memory of that expert on the stand. The calm certainty in her voice, the way she explained that pressure leaves marks you can't erase. And ink carries time whether you want it to or not. I think about that often now, in situations that have nothing to do with wills or courts. When someone insists there's no need to look too closely, when they rush a signature, when they frame questions as accusations instead of safeguards, I pause. I look, I ask anyway, and if that makes me difficult, so be it. Because I've learned something most people learn too late. Being easy to deal with is not the same as being safe. If you've stayed with this story to the end, thank you. Truly. I want to ask you one last thing. Something worth thinking about long after this ends. Have you ever almost accepted something that didn't feel right, simply because everyone else wanted it to be over? If you have, leave a comment. Your answer might be the reminder someone else needs to take a second look. Because sometimes, the smallest details are the only things standing between you and being quietly erased. I didn't expect the consequences to keep unfolding after everything was resolved. But resolution on paper doesn't always mean resolution in real life. 3 months after the estate was finalized, I received a letter from the state bar. Not addressed to me directly, but copied to all named beneficiaries. The attorney who had processed the altered document was under formal review, not for criminal intent, but for failure to follow protocol. He hadn't verified the draft history. He hadn't insisted on private consultation with my father. He had trusted convenience over caution. The letter was neutral in tone, procedural, almost dull, and yet it mattered, because for the first time, the story wasn't framed as a family disagreement. It was framed as what it actually was, a breach of process. Laura didn't contest the findings. She couldn't. The handwriting report had become part of the record, referenced in a way that made future explanations irrelevant. No amount of confidence could outtalk physics. A few weeks later, an acquaintance forwarded me something without comment, a screenshot from a professional forum. Laura had applied for a fiduciary role with a private foundation. Her application had been declined. No reason given. None was required. Reputation doesn't collapse loudly. It thins, quietly, opportunity by opportunity. I felt no satisfaction reading it, only a sober understanding of how permanent certain marks can be once they're made visible. The last update came nearly a year later. A short notice confirming that the estate file was officially closed. No further claims. No outstanding actions. That was it. No final confrontation. No reconciliation scene. No apology letter arriving late. Just an ending that stayed ended. I framed the handwriting expert's summary. Not the ruling. Not the will. The summary. It hangs in my home office now. Not as a trophy, but as a reminder. It doesn't mention my name, or Laura's, or money. It talks about pressure, about ink saturation, about time, about how materials remember what people try to overwrite. If there's one reason I agreed to tell this story, it's not to warn you about inheritance or family disputes. It's to remind you of this. When someone tells you not to look too closely, that's usually the moment you should. When they rush you, simplify things for you, or frame questions as disrespect, that's not peacekeeping, that's control. And if you ever find yourself thinking, maybe it's not worth checking, remember this. Erasure doesn't happen all at once. It happens one quiet substitution at a time. Until someone checks. Have you ever discovered the truth only because you refuse to stop looking? If you have, share your experience in the comments. Thank you for staying with this story, from the first missing name to the last closed file. There isn't a dramatic final scene to end this with. No phone call where everything is suddenly forgiven. No moment where someone admits they were wrong and asks to start over. What I have instead is clarity, and that's more durable than closure. The year after the file closed, my life looked almost exactly the same from the outside. Same work, same routines, same quiet habits. But internally, something fundamental had shifted. I stopped assuming that fairness would protect me. I stopped believing that good intentions were a substitute for safeguards. And I stopped feeling guilty for wanting proof. The truth is, nothing about this story required me to be brave. It required me to be attentive. That's what people misunderstand. Standing up for yourself doesn't always look like confrontation. Sometimes it looks like asking for a copy, like noticing a margin that's slightly off, like trusting the part of your brain that says, "This doesn't match." Laura and I remain strangers now, linked only by shared history and a legal record that neither of us can rewrite. I don't wish her harm. I don't wish her redemption either. I've learned that not every relationship is meant to be repaired. Some are meant to be understood and left where they are. As for my father, I think about him often, not with anger, with a quiet sadness that his final months were used to rearrange something that was never meant to be hidden. I take some comfort in knowing the truth outlived the alteration, that what he intended wasn't lost, only delayed. People ask me now, when I tell a shortened version of this story, whether I'd do anything differently. The answer is simple. I would look sooner. I would ask earlier. I would trust myself faster. Because here's what I know now. Without hesitation, if someone assumes you won't check, they've already made a decision about your worth. And if a system reveals the truth when people won't, that system is not cold, it's protective. If you've stayed with this story all the way to the end, thank you. Truly. Not for agreeing with me, but for listening carefully. I'll leave you with one final question. Have you ever realized, too late, or just in time, that paying attention was the only thing standing between you and being quietly written out? If you have, share it in the comments. Your experience might be the reason someone else decides to look twice. I didn't plan to add this, but a few weeks after everything ended, I received an email from someone I didn't recognize. No subject line, just a single sentence. I read your case file. I checked a document I'd been ignoring for years. You saved me. That was it. No details, no explanation. I sat with that message longer than I expected to, because this story was never about winning $10 million. It was about noticing, about refusing to be rushed out of your own life, about understanding that small details aren't small when they're the only thing standing between you and being erased. If there's a quiet takeaway here, it's this. You don't need to be loud to protect yourself. You don't need permission to verify. And you don't need to apologize for reading what you're asked to sign. Sometimes, the most powerful thing you can do is slow down and look twice. Thank you for staying with this story, from the missing name to the final file closure. If it made you think of a document, a conversation, or a moment you've been putting off checking, maybe tonight is the right time. And if you've ever caught something just in time, or wish you had, share it below. Your comment might be the reason someone else doesn't get quietly written out.